Hi, I'm Kelly Longtin from Kelly Longtin Law, and today I'm going to talk to you about ancillary probate, what it is, when it's used, where it occurs, and how you can avoid it. Now, many people own property in more than one state, perhaps a vacation home in Florida, a rental property in a former home state, or even a car titled in another state. It is important to think about how that property will be handled as you create an estate plan. It may be necessary for there to be an additional probate proceeding called ancillary probate. Through proper estate planning, however, this result can be made less burdensome and even avoided altogether. So what is ancillary probate? First, a probate proceeding is the court process that must take place to transfer property you owned at your death to the family members and loved ones that you've named in your will, or to heirs designated by state law if you don't have a will when you pass away. Probate is not required for property that you have placed in a trust or that automatically belongs to a surviving joint owner upon your death, such as a joint bank account or a marital home owned by you and your spouse as joint tenants. In those situations, you no longer own the property or money at your death, so probate is unnecessary. In situations where probate is required, more than one probate proceeding may be necessary if you own property in more than one state. Typically, the law of the state where real estate and sometimes tangible personal property, meaning property that you can physically touch, such as a piece of jewelry or a painting, is located, determines what happens to that property when you pass away. Intangible personal property, such as a copyright or a trademark, and in some states, a retirement or a bank account, can be probated in the state where the property owner was living at death. This is a situation that most people try to avoid because it can involve more of the same types of costs associated with probating an estate: court fees, accounting fees, and attorney's fees. In addition, it means a double dose of all of the other disadvantages associated with probate proceedings. For example, a long waiting period before the property is transferred, and the lack of privacy arising from public court hearings and records. The primary, sometimes called domiciliary, probate proceeding takes place in the state where a property owner was living when he or she passed away. An ancillary probate proceeding is typically necessary if the person who died also owned real estate in another state. In the primary probate proceeding, the court establishes the validity of the will, admits the will into probate, and then appoints the executor named in your will to manage the estate. The executor locates the property, pays any outstanding debts, and then distributes the property according to the instructions left in your will. Although state law varies, once the will has been found to be legally valid during the primary probate proceeding, probate courts in other states will often allow the executor appointed in the primary probate proceeding to file the necessary probate letters issued in that proceeding, as well as a court-stamped copy of the will, in the probate court in the state where the real estate is located. At that point, the executor can exercise control over the property in the other state. For example, transferring it to your beneficiaries as specified in your will, in accordance with the procedures mandated by that state's law. Now keep in mind, ancillary probate will also be necessary if you die without a will while owning real estate in another state, unless you've taken one of the steps that I'm going to discuss with you in a couple minutes. If you do not have a will, state law will determine who will receive the property. Because state law varies, it is possible that the heirs specified in the law of the state in which you are living when you pass away are different from the heirs named in the law of the state in which your out-of-state property is located. So how can ancillary probate be avoided? Well, through joint ownership or transfer on death deed or revocable living trust. So let's talk about joint ownership. If you own property jointly with another person, for example, by joint tenancy with rights of survivorship, tenancy by the entirety, or community property with the right of survivorship, the property will automatically pass to the joint owner without the need for a probate proceeding. This type of ownership is typically used for real estate, bank accounts, vehicles, and other valuable property. Usually, the surviving owner only needs to fill out forms that can be submitted to the government office that has recorded the deed or title, the bank where a joint account is located, or other similar entity, and probate is unnecessary. Although joint ownership of property avoids the probate proceedings and might seem like a quick and easy way to transfer property, the money or property jointly owned is now subject to the surviving owner's creditors, divorcing spouse, or bankruptcy. Now, let's talk about transfer on death. Now, a transfer on death deed. A few states allow you to file a special type of deed that will not become effective until your death. It's called a transfer on death deed or a beneficiary deed with the local real estate records office. Unlike joint ownership, you retain complete control over the property during your lifetime, and you can even revoke the deed anytime before your death. The persons named in the deed automatically receives ownership of the real estate only upon your death, and a probate proceeding is avoided. Similarly to joint property, transferring real estate using a transfer on death deed provides no protection for the real estate and could make it vulnerable to the new owner's creditors. Now let's talk about a revocable living trust. If you transfer the title of the property located in the other state into your revocable living trust during your lifetime, you can avoid this ancillary probate process. This is because the trust, not you, owns the title to the property. Because the trust continues after your death, a probate proceeding is unnecessary. If you want to avoid probate altogether, you can also transfer your accounts and title to property located in your home state to the trust as well. If you name yourself as the trustee, you can retain complete control of the property and can even revoke the trust at any time during your lifetime. It only becomes irrevocable upon your death, or if you no longer have the mental capabilities to revoke the trust. While you're alive and unable to act as the trustee, your successor trustee that you've named will continue to manage and distribute funds for your benefit. Now, upon your death, the successor trustee will distribute the property to your family members and loved ones when and how you have specified in the trust instrument. We can help make things easier for your loved ones when you pass away. The last thing your grieving family members and loved ones need is a lengthy, expensive, and complicated process to handle the transfer and disposition of your money and property. If you own property located in another state, the potential hassles they may face could be multiplied if you do not have a well thought out estate plan in place. We can help you create an estate plan that will enable you to have the peace of mind that comes with knowing that you have done everything you can to minimize the cost and hassle for your family when you pass away. Call us today to set up a meeting so we can discuss an estate plan designed to make sure all of your property is transferred to your beneficiaries as you wish, regardless of whether it is located in your home state or in another state. Thank you for watching. I'm Kelly Longtin from Kelly Longtin Law.